Good morning. I hear we have a change in order.
Yes, Chief. Calling the second case in our list, Commonwealth v. Robinson Tejeda, SJC-11858.
Good morning, Mr. Kern.
Good morning. May it please the Court, Dana Curran for Robinson Tejeda. With me is Robert Sinsheimer, who is trial counsel in this matter. The main issue that we're focusing on is actually the Commonwealth's appeal, but since we also have an appeal, and I filed a blue brief, I'll be going first. In 1863, this court decided Commonwealth versus Campbell, which adopted the so-called agency theory of felony murder. And that theory holds that criminal defendants are responsible only where the defendant himself or one of his accomplices kills somebody in furtherance of the underlying felony. That case has never been overruled. It's widely viewed throughout the country as the leading case on agency. It's widely cited, and it is, notwithstanding the Commonwealth's arguments, it is still the law of this Commonwealth.
I'm having a little confusion reading Judge Sanders' memorandum. She gave an instruction that she said was consistent with the new homicide instructions. Is that right?
Well, that's what she said.
So, yeah, I don't know if you can see where I'm going with this. Are the instructions, on your view, wrong? The
instructions are wrong. The instructions are actually wrong under either the proximate cause theory or the agency theory. It would be right in the overwhelming majority of cases where there's no question as to causation and there's no question as to who did it. But in a case, this is not the typical case. And what she instructed was she gave three elements. The defendant committed or attempted to commit an armed robbery, that the death of Mr. Tejeda occurred during the commission or attempted commission of that armed robbery, and that the underlying felony armed robbery was inherently dangerous or the defendant acted with conscious disregard to the risk of human life. That's three elements. What was asked for was...
So under the proximate cause theory, what's wrong with that?
What's wrong with it? It doesn't talk about causation. I'm sorry, it doesn't talk about foreseeability. There was, and foreseeability is actually an element either of agency or the proximate cause theory. Is the death reasonably foreseeable during the course of the felony? Because there may be things that are just not foreseeable that you could get a sort of a Rube Goldberg situation where some event happened and even under the proximate cause theory adopted by a minority of states, it has to be reasonably foreseeable, and that was never given.
Well, is the issue foreseeability or is the issue joint venture? I mean, if somebody stumbles and a gun goes off during the course of a robbery and someone is killed, it's killed by a joint venturer, would you say that that would not be felony murder?
Oh, I think that probably would be felony murder. The issue, actually the main issue in this case is not necessarily foreseeability, but it's whether the act that caused the death was committed by the defendant or one of the accomplices.
In furtherance of
In
the
furtherance
joint
of
venture.
In furtherance
yes.
of it.
And isn't that sort of a classic definition of where an act of one conspirator or joint venturer belongs to the other?
No, isn't it more that the in furtherance, if somebody else kills one of the purported robbers, is that in furtherance of the armed robbery? Isn't that the issue?
It's an act by, in this case, it's an act by a third person, by the intended victim of the armed robbery who killed one of the accomplices.
Right, I understand in this case, but I mean, it seems that what you're asking for would be essentially a joint venture instruction, which says that when the person is responsible, if that person or another joint venturer were to kill somebody in furtherance of the robbery, then that person is responsible for that death.
Yes, and I don't have a problem with that type of instruction as long as the instruction focuses on that the death was the direct result of an act by the defendant or one of the joint venturers. That was actually the specific request for an instruction, and that wasn't given.
Well,
Does it make any difference here? This is a slight shift from what you're talking about, but it's along the lines of I think the Santiago case. Does it make any difference here that both the perpetrators and the victim of the robbery were both engaged in illegal activity? So the victim in this case was not a truly innocent party. This is more like the case where the gangs were shooting it out.
I don't think this is. I mean, in Santiago, the gangs were shooting it out. They were both doing the same thing there. The underlying felony was shooting at each other. In this case, the underlying felony is an armed robbery.
it's not selling drugs.
Right, it's not selling drugs. It's an armed robbery. And during the course of the armed robbery, somebody resisted, the intended victim resisted the armed robbery. There may be situations where the intended victim does that, or a police officer comes on the scene and does that, or a third party, some innocent bystander says, oh, look, there's an armed robbery, and starts shooting at people. Now, do we want to make defendants responsible for the acts of third parties? The answer that this court came up with in Campbell, which has never been overruled and which has been followed by Bolero, by a number of cases in the 1980s, it is very clear, this court has made it very clear that it has to be an act of the defendant or a co-defendant in furtherance of the underlying offense.
So if you have an armed robbery and the victim of the prospective armed robbery shoots back and misses and shoots a totally innocent bystander who's walking down the street and kills the innocent bystander, under your theory, is not a victim of a crime.
Well, the innocent bystander, under the agency theory, is not a victim of the crime. In about 10 states, the innocent bystander would be a victim of the crime. I think it's something like 23 states, we follow the agency theory where that person would not be the victim, or the defendant would not be held responsible for that killing. There are a number of other states that by statute would say would maybe exclude, by statute would exclude an accomplice. So if there are some states that say if someone other than an accomplice is killed, then you're held responsible. We've never actually gone that far. Massachusetts has never held that an innocent bystander the killing of an innocent bystander constitutes felony murder if the shot was fired by somebody other than a participant. And when you look at malice, felony murder is actually, there's a legal fiction involved where we take the intent to commit the underlying felony and we use that as constructive malice. In essence...
And isn't that the same fiction, though, that's involved in the alternative tort theory?
Well, it's one step removed.
But I mean, it's that you, by trying to participate in the crime, you take all the consequences of that crime.
That's true. That is true. But it's what some states have said is that that essentially eliminates malice. Some states have characterized it as eliminating malice because the person who fires the shot is not acting with malice. Some states have said, well, that may still be malice, but it's too attenuated. It's one step more attenuated because that killing is committed by someone other than one of the participants. So we choose to draw the line at that point.
Is the shooter, the victim of the armed robbery, the shooter, is that person responsible for a crime?
The shooter may be, and in this case, the shooter was actually charged with felony murder, and he was acquitted. Was determined that he acted in self-defense. So he may be, if he is engaged in a dangerous felony, then he may be guilty of felony murder. But it may also be a police officer. It may also be some innocent bystander, and so it's a somewhat of a difficult line to draw. And if we're drawing lines here, again, if this court decides that maybe felony murder should be extended, there's a line to be drawn between an innocent bystander and an accomplice.
But what would be the rule? I mean, how do you articulate why under an agency theory it's okay to find an an innocent? It's okay to charge the defendant with the innocent bystander's death, in Justice Spina's example.
It wouldn't be the agency theory. We'd have to abandon the agency theory and say we're no longer going to be an agency theory state. Under the agency theory, the defendant would not be responsible. And that is actually the law in Massachusetts. This court can probably choose to abandon that rule, but I think it really has to be prospectively only. I don't think you can say, well, Mr. Tejeda was entitled to an instruction on the law at the time, which is that we have an agency theory, and if the victim is an innocent is an accomplice, then he can't be held responsible. And I think the judge recognized this, and maybe she was hoping that the jury would come back with a not guilty and avoid the problem. But they came back with a guilty based on the sort of flawed instructions, and then she set it aside. And I think she was correct in doing that. And she recognized that we are an agency theory state, and the defendant is entitled to that instruction, or is entitled not actually to that instruction, but to a not guilty.
So under the state of the common law in Massachusetts, the defendant in this case is not guilty.
He's not guilty. He's absolutely not guilty. And one other point.
Sorry, not guilty of felony murder.
Not guilty of felony murder.
Still guilty of armed robbery.
Yes, I do address that in my brief, and I'm going to leave that to the brief probably.
And I gather that the armed robbery conviction was never vacated in light of the felony murder conviction.
No, it was not.
So if you prevail, your client's guilty of armed robbery.
Yes.
And would that
8-year sentence, doesn't he?
6 to 8 year sentence.
and would that would the Commonwealth be entitled to resentencing because of the sentence arguably being affected by the felony murder conviction?
I'm not sure. I don't think so. I think the judge contemplated this scenario, and I think that was a sentence that she intended to impose. And
which came first, the sentencing or the vacating of the felony murder?
I don't remember. It may have been at this. I think it was at the same time. May have been at the same time.
My memory of her decision seems to indicate that she did contemplate the dismissal of the.
Yes, the written decision came later, but the initial decision to allow the motion, I think, came at the time of the sentencing, or maybe before the sentencing. But the one other point, the last sentence before the conclusion in the judge's decision is, she set it aside in the interests of justice, and that was essentially allowance of a Rule 25 motion. The Commonwealth makes no argument that that decision was wrong, and
is that because of the agency theory, or is that because he was the driver, or what do you? I mean, she didn't articulate that, right?
She didn't articulate that, but it probably based on the all of the foregoing discussion and the fact that there is what I argue in challenging the felony murder. I'm sorry, the armed robbery and the home invasion is that the evidence was extremely thin on that he knew, I mean, our contention is that he knew that he was driving his co-defendants to a drug deal, but he didn't know about the armed robbery. And the jury acquitted him of the firearm charge.
Wasn't there some expression about where we caught a lick, or there's something about the word lick?
There were discussions about that, but it was all after the fact. After he went in and, ATN came out and then he found out what happened, and then he called his friends and says, we went to catch a lick. Well, he didn't make any of these statements prior to the fact, prior to the robbery taking place. So that's sort of our argument on that. Unless there are any further questions, I'll leave the remaining points to the briefs.
Thank you, counsel.
Thank you.
So you've changed, your view is we've actually changed the common law over time.
Good morning,
and
Your Honor.
abandoned Campbell.
Yes, that's the Commonwealth's position, that the, good morning, Your Honor, may it please the Court, Vincent DeMore on behalf of the Commonwealth. I suppose I should be used to this by now. Yes, precisely, that over time, starting with Campbell, through Bolero, and most recently in Santiago, which this Court indicated that it had a very dim view of the holding in Campbell moving forward, that the evolution of the common law has been such that essentially the proximate cause theory is in fact the law at this point.
But were both sides engaged in illegal activity here?
Both sides were engaged in illegal activity.
But not
One-
the same illegal
same.
activity.
Different illegal activity, yes, I would agree with that. One side thought they were selling drugs, one side was stealing drugs, in essence. So,
And it wasn't just stealing, I mean, it was an armed robbery.
yes, through the use of force, yes, correct. And I think what I'd like to do, if I could, just to, in sort of stepping back, when we talk about this being, the felony murder rule being a common law rule, I think it is important to place it within the context of precisely what that means to be part of the common law. And certainly, in law school, they teach us that it's judge-made law, whatever that exactly means. But really, it's the expression of society's expectations and mores and the like. And whereas it used to be the juries in the 100 courts in the Shire, England, today we have this court, which essentially is the vessel or the medium through which it speaks. And I think it's important when we look at the facts of this case and the legal question before the court today, that we also remember that in America today there are 300 million firearms for just slightly more people, 308 million, and that the use of firearms in the course of armed robberies has doubled over the course of the last 15 years as a matter of percentage. So I think with regard to society's expectations, when you go to rob a drug dealer with a firearm, and certainly the defendants in this case contemplated that force was a foreseeable consequence, otherwise they would not have brought a firearm, that the death of someone, whether it's a co-conspirator, an innocent bystander, or the targets of the robbery, is certainly a foreseeable consequence.
But if just, you make that point and where society is now and the development of the common law, but as I take it, the common law and the statutory law of a not insubstantial majority of this country has adopted some version of the agency theory and not the proximate cause theory.
Yes, and that's true, and I suppose I could say that it's an opportunity for this court to lead the way. But yes, other states have abandoned the felony murder rule in its entirety. Other states have adopted the agency rule. Other states have adopted the proximate cause test. And I'd suggest, and I think Justice Spina's question, I think, got to the heart of it, with regard to what exactly would society expect. And if two individuals are engaged in precisely this behavior, but not in a basement, but instead on the street, and a child is shot across the street, would that child not be a victim? Would society not expect that someone is held accountable for the death of that child?
Would no one be held accountable in that example? Would no one at all be held accountable, or is it just a question of how many people are held accountable?
I think it's both, because if we take the facts of this case, where we have one party who's acting, and in fact was acquitted based upon self-defense, right, then the act of firing the fatal shot was in self-defense. It just so happened to have hit an innocent bystander. So I think in that case, I think that person would in fact be acquitted of any murder charge.
Isn't that the odd result? The one who actually fires the gun is found not guilty?
No, I think the odd result is that the person who intentionally created a situation which is a hazard to
They
human
both?
life. I'm sorry?
Didn't they both? in this situation, create the situation?
No, the victims of the robbery created a situation by which they could sell marijuana. That was their intent, not to engage in a shootout, not to have to use force. That wasn't something they intended to do. They intended to sell $1,000 or $2,000 worth of marijuana. That was their intent.
But they had a gun.
They did, yes, because the narcotics.
On that theory, then, you use the gun in connection with selling the drugs, and you take your chances on whether or not that's going to result in a homicide conviction.
Well, I think the fact remains that with regard to those defendants would be acting in self-defense. If we change the facts, and for instance, I think if we look at Bolero, and we take the facts of Bolero, I think if we apply the facts of Bolero today, especially after the holding in Santiago, I would suggest that society would expect that people engaged in a home invasion in which a child is caught in the crossfire, and it's the police officers on the other side, that someone will be held accountable for that. And I think that
If it really were an innocent child that were killed, and the victim in this case had shot an innocent child as opposed to one of the perpetrators, do you really think that the jury would have acquitted on self-defense?
I do not know what a jury would do. I think I think it's entirely possible if we assume the jury follows the jury instructions, that they were threatened with deadly force, they responded with deadly force, and their marksmanship just so happens to be poor, I think that would probably have to result in acquittal of the actual shooter who was acting in self-defense. And I think that the proximate cause theory.
Boy, it doesn't pay to be an innocent bystander anymore.
It doesn't. I think that's precisely the point, though, is that really the agency theory relies upon essentially a bedrock, fortuity here, right? There's simply good luck or good marksmanship. That criminal liability is falling on the side with the best shooter, in essence, whereas where it ought to fall is on the person who created the conditions. And our entire purpose of our homicide laws, and the felony murder doctrine in particular, is to dissuade people from engaging in activities which are inherently dangerous to human life and which is intended to cherish human life, to avoid the act of killing by others. And I'm not going to suggest that someone who's now been convicted of armed robbery and is facing a state prison sentence has been rewarded in any form or fashion here. But certainly, they are avoiding criminal liability merely by virtue of the relative marksmanship of the parties and the relative allegiances which form that.
Under the proximate cause theory that you suggest we have already moved to adopt, if a police officer were to come on the scene and there was a shootout and an innocent party were shot by the police officer, that would be the responsibility of whom?
Of the defendant, the individual who created the condition.
Even if, okay, so the defendant creates it, there's crossfire from the other side, the police show up, it's the individuals who created the dangerous situation that would be culpable under the proximate cause theory.
Exactly, and it may be too simplistic a formulation, what I'm about to say, but in essence, I think if one steps back and sort of from a lay perspective asks, who's at fault here, right? Who's to blame for the situation? Who's to blame for creating this condition which resulted in the loss of human life? In essence, based upon the public policy rationale for the felony murder doctrine, who is it that we wish to dissuade from engaging in behavior that resulted in death?
In this case, wouldn't it be everybody who had a gun, including the victim? Including the victim?
I'm not condoning the behavior of a
sold
drug
them the
dealer
guns,
who's armed with a
too.
firearm. I agree. And in fact, I think that also gets to the heart of it.
So, what is creating the condition? What is the condition? Is it identical to the underlying felony? No, it seems not. It seems like there were two underlying felonies, one the armed robbery, the other drug sales.
Well, it was a misdemeanor in the case of
I'm sorry.
the narcotics.
Okay,
as
well,
marijuana,
whatever, but there are still two different illegal activities, and it's hard to say that only one of those illegal activities was the condition.
Well, I actually would disagree with that because I think we've already said that only one of those is one which is inherently dangerous, or in the way it was carried out was dangerous to human life, and that's the armed robbery.
But we issue no-knock warrants all the time when there's a drug sale.
Yes.
And it doesn't matter, I don't think, whether it's marijuana or cocaine.
I agree, and I think that there's I think the distinction that exists between the felony and the misdemeanor, I don't think is candidly particularly meaningful because the activities in question are equally wrapped up in the violence that's concomitant with the narcotics trade, and I think that's also part of this.
Mr. DeMore, I do worry about incorporating tort principles into the criminal law. where so much of what the criminal law means is that people are responsible for things that they intend to do. Intent is a bedrock of our criminal law. So it's worrisome to suggest that we should treat crimes in the same way that we treat torts, when we obviously care more about protecting people in criminal prosecutions than we do in the tort situation.
Well,
It's not like nobody is going to be punished.
Well, in fact, as it stands, no one is going to be punished for the death of Christopher Pichardo if the things remain as they are today. But I think that to that point, I think that proves too much, because if it's a question of the intent, then that's the entirety of the felony murder doctrine out the window, because the felony murder doctrine substitutes the intent. The malice is substituted by the intent to commit the underlying felony. So if the contention is that there's an issue with the intent portion of the culpability, then that simply is an argument against felony murder in its entirety.
Mr. Curran suggests that this change should be applied prospectively. Your position is it really isn't to change at all?
Yes, that when we look at the evolution from Campbell to Santiago, especially coupled with the language in Santiago, in which this court indicated that it is very much so unsure as to whether or not the holding in Campbell is still good law. I do understand. I would entirely understand if the decision were to be applied prospectively. That I don't think that's a crazy result. But it's our position that it's a evolution over time. Yes.
And you say there'd be no punishment, but armed robbery is a life felony, potentially life. Why would it not be viewed as an aggravating factor in a judge's determination of sentencing on the underlying armed robbery?
I think it certainly could be, but that's still, there's still no punishment for the death itself. The death itself may be taken into consideration when meting out the punishment for the armed robbery, the other crimes associated with the incident. So we're taking the facts in their entirety, sure. But at the end of the day, no one essentially no one is responsible for the death of Christopher Pichardo here. And I think...
Well, no one's responsible, but it doesn't matter that somebody was charged with it? Yes, the jury found him not guilty, but he was charged with it, the actual shooter.
And I'm sorry, are we referring to Mr. Reynoso?
Yes, I am referring to Mr. Reynoso.
Yes, he was charged, and he was acquitted. And I would suggest when one looks at the evidence in this case, it's difficult to really come to a different conclusion than there was self-defense at work there. When one applies the elements, the application of deadly force in a basement, no opportunity to retreat, and the use of force was not disproportional to the use of force applied to him.
What about the argument made that what the judge was doing here at the end of the day was also exercising her authority under Rule 25? Well,
the notion that the verdict is set aside because it's not consonant with justice, without more, I'd suggest it's simply insufficient to do it on that basis. Essentially, I disagree with the jury's finding here. I would have acquitted him, is the way I view that, without anything more being said.
But that's what Rule 25 allows,
Well,
doesn't it?
but I think to set aside a murder verdict, there's a long decision indicating why, in the court's view, the trial court's view, that the agency theory bars this conviction, and then it's set aside, and then there's sort of an aside. It's really a one sentence. And by the way, I do this also because it's more consistent with justice. To me, that looks more like under 33E, where there's the reduction in the degree of culpability. Essentially, that sort of exercise.
Well, if she had said, I do it because it's more consonant with justice, because Mr. Tejeda was in the car, he wasn't on the scene, the evidence was weak with respect to what he, I mean, I'm making this up, but the evidence was weak with respect to what he knew about what was going to happen other than the drug sale, that there was armed arms involved. Would you have a problem with that?
I would.
I mean, is it a problem of not articulating or a problem with the bottom line?
Well, it's hard to answer the bottom line question without the articulation, so I think that's certainly part of it from a procedural posture. But with regard to the, essentially what it would be saying is that that the evidence was sufficient to convict the defendant. A jury who was selected to decide the guilt or innocence of the defendant has returned a verdict of guilty, and I simply disagree with the jury's verdict. And I'm not sure that's consonant with justice. This is the reason why we have juries in the first instance. And I see I'm nearly out of time. If the court has any further questions, I'm happy to answer those. Or
Thank you, Counsel.
thank you.